we had a guy on the jury, John, that was a construction worker that had been shocked by 120 volts a dozen times and never been hurt.
Why did you leave that guy on?
Because everyone else was worse. We had an insurance adjuster on the jury.
Stop.
Yes, we had a white shoe law firm lawyer, business lawyer, as the foreman of the jury.
You got to be kidding me.
Dude, I picked the jury like, we're going to lose this case. This is unwinnable.
All right, everybody, welcome to another great episode of Cases Gone Wild with me, your host, Jon Marko of Marko Law. And I've been doing this for over 15 years, and I bring you on this show, as you know, the craziest, wildest, most insane, exciting cases that you will not believe, but they're real. And we have a very special guest, one of the top trial lawyers in the entire country, born in Detroit, Michigan, top trial lawyer in Colorado. Some of the biggest, best, wildest, most electrifying verdicts, and I mean that literally and figuratively. Kurt Zaner is going to join us today, all the way from the great state of Colorado. If you like the show, please share it with your friends. Give us thumbs up, 5 stars, whatever they do. I don't know how that works. But please remember, we're filming live, so go to the YouTube channel, or you can watch it on all your favorite streaming platforms. Kurt, thanks for joining us, man. It's an honor to have you on the show.
Hey, John, thanks for having me, dude. That was an electrifying intro. It sounds like maybe you give that for all your guests, but I loved it. I'm gonna record that and then play it before I go to bed at night, so I can feel really good about myself. That was amazing, man. No, it's great to be here. Thanks for having me. I've watched the show. Obviously, we're pals. We've met all over the place. I see you lecturing everywhere, knocking crazy verdicts out of the ballpark, and being in the news. I mean, I feel like we're kindred spirits. So I'm honored to be here. Get to hang out. Shoot the shit. We ought to say shit. I don't know. We're gonna get.
Yeah, you can say whatever you want on the show. This is like they put an explicit advisory on the show.
Oh, that's great. All right, so good. I'll keep my clothes on.
It's great to have you. You know, dude. Same about you. Like, can I ask you how old are you, Kurt? Because I don't think I know. Are you around my age?
45 years old.
Yeah. So I'm 41. So we're like similar age group. I feel like it's kind of similar aspect of our career. I love following your verdicts. Just so our viewers who may not know you, if they're not, because there's a lot of non-lawyer listeners, but you have, I mean, record-breaking verdicts, largest premises liability verdict in the history of the great state of Colorado ever, of $16 million. You have the largest personal injuries verdicts in federal court out there, $30 million. I met you when you were speaking about an electrocution case, which I handle a lot of electrocution cases, so I know I've called you for advice. 10.6 million. Oil company. I mean, the list goes on and on, dude. I mean, you have the big verdicts, but more than just having the big verdicts, you're a great person, a caring person, and I really respect that about you.
Well, John, man, thanks, dude. It's like I remember when I had no verdicts and I was just trying to figure out and learn from everybody else. And I watched this movie, The Edge. Have you seen the movie The Edge with Alec Baldwin and Anthony Hopkins?
I don't think so.
Oh, dude, it's a classic. They get stuck in the Alaskan wilderness. And Anthony Hopkins is this billionaire philanthropist. And Alec Baldwin is his photographer. And they're stuck in the wilderness. And this grizzly bear is hunting them. Kills one of their friends, spoiler alert. And it's going to kill them. And Anthony Hopkins gives Alec Baldwin this amazing speech. He's like, "You want to die out here, don't you?" And he's like, "What can we do? The bear is stalking us." And Anthony Hopkins gives him this great pep talk about, look, a man can kill a bear. What one man can do, another can do. What one man can do, another can do. And then this mantra goes on. And finally he gets Alec Baldwin to say it. And then they try and kill the bear. And so I saw these great trial lawyers. I'm like, I want to do that. So it's cool to have some success, been really blessed with success, and try and be the same person, right? Like try and be kind, try and be open to learning, and just try and be a good human. I think that's the key to being a great trial lawyer, is being
what was your career trajectory? Like when, how did you get to where you are Was it a circuitous route? Was it, was it a straight line?
Yeah, no, it was very circuitous. So I clerked for a federal district judge out of law school. I really want to go on and become an AUSA. So then I took like a big firm, quasi big firm job down in Miami where I was, because I grew up in South Florida after leaving Detroit. And then down in Miami, I was doing like commercial litigation, plaintiff's class action, and I hated it. I hated billing hours. I hated keeping track of the time. So one day I drove to the ocean, tore off my suit, went swimming in my underwear and said, never again am I going to bill hours. I quit my job, bought a one-way ticket to South America, traveled for like 7 weeks, ended up taking 10 months off, moved to Colorado, followed my heart, prayed on it where I wanted to be. And then I got to Colorado and said, I need trial experience because I want to be a trial lawyer. Took a job as a criminal defense attorney.
Wow. That's like the Jerry Spence, man. Jerry Spence was like representing, I think he was a public defender, but representing people and, getting that experience.
There's no better trial experience. I was in court, so I did criminal defense for 1 year. It kind of felt like 7 years, like kind of like dog years. I was in court every day, at least twice a day, maybe 3 to 4 times a day, getting double set in 2 different counties at the same time. I got like 11 trials, and you talk about trial by fire. It's like, here's your file at 6:30 the night before, trials at 8 a.m. Go learn it. And as a criminal defense lawyer, public defender, although I was private, you get the opportunity to learn how to cross police officers. And I think, and you had, and the cards are stacked against you. So it was incredible training ground for me. I did that for a year, tried a bunch of cases. And then again, I was like, I hate being a lawyer. I quit and I took another year off. And I said, I went like retraced William Wallace's steps in Scotland, the Braveheart character, real life. I listened to the ground, I prayed, I journaled. I came back and said, listen, I think I still have something left in the tank to be a lawyer. It's like 3 years in. And I ended up joining a PI firm. Like, I'm going to start a PI firm one day. I got to go learn a little PI, personal injury. And so I got a job at a big advertising firm here in Colorado. Lasted there about 4 months and then started my own firm, Zaner Law. And then my buddy joined me. Man. And my buddy joined me. I'd be remiss not to talk about him because it's now Zaner Law again. But my buddy Mark Harden joined me. We had this beautiful success for like 13 years. And now Mark has moved on to the music industry. Talk about a career pivot. And he's more in the electronic music world, producing, DJing. He's been in Ibiza the last 2 weeks. It's wild. And now it's Zaner Law again, how it all started. So it's been
well, I think you found it, man. I think, you found that sometimes we don't get what we want, we get what we need. And now it sounds like you have both. So I'm really happy to follow your success. And you're on Cases Gone Wild. So we got to start with some of your crazy cases. Where do you want to start? I mean, dude, you have a lot. I mean, the largest premises verdict. Where do you want to start?
Why don't we start at my first 8-figure verdict, the $16 million premises liability one. This case, this is a wild case. I've talked about it a lot. It's not my biggest or my most recent, but man, it's one of the stories I just have to tell. All right, so let me set the table. Construction project. There's a new house being built, and they put in the floors. They put the floors in before everything else goes in. So the house is constructed, the floors are going in, and my guy's a flooring installer, and there's no power inside the house. So he has to get power for his flooring machine outside at an electrical, they call it a pedestal. It's like a box, kind of like a breaker box you have in your house, but just with like 3 breakers on it. So he goes to plug in his machine and boom, there's an explosion. My first electrocution case. His hand turns black, but it's just kind of like, we think the sparks, we have no pictures of that. And he goes to the hospital and he develops this thing called complex regional pain syndrome. CRPS, or CRIPS as people call it. Again, my first case doing this. So we got to learn the science behind that. It's where your sympathetic nervous system starts going haywire and it starts delivering pain signals where it's not supposed to. And now where it usually controls heat and cold, fight or flight, it's now like always in fight or flight. And all these things just send pain signals, and it can spread from your legs to your arms. It can turn your limbs blue. It can get really bad. He had it in all 4 limbs, but things weren't blue, but he couldn't work anymore. Father of 3, which I identify with, got 3 little boys myself. So someone else has the case. We get it 2 weeks before the statute, before you can't file a lawsuit anymore.
Yeah, story of my life,
Right. And the very good lawyers had it in Boulder. And they said, look, we don't want the case because the defendant destroyed that box. That box that exploded, gone. They threw it away. So we said, well, I'm sure there's good like spoliation law for your non-legal listeners. That's where someone destroys evidence and gets sanctioned for it. I said, we'll take the case because I fell in love with the guy. He was amazing, 33 years old. We take the case, and spoliation law is not very good in Colorado. It's much better now because of this case. And we have to figure out why the box is destroyed. And what we get is what we call it was a moving fiction. These defendants that destroyed the box told a different story to different people 4 different times. They told the workers' compensation investigation folks one thing. Then they told another set of people another thing. Then they told us a different thing in their interrogatories, and then yet another story in the depositions. So this case, John, got really juicy because now it's about the cover-up. Now it's about the lie. And we really need this box because that's what we have to prove, that it was negligently constructed or that it was a dangerous condition for a premises case. We pled both of those. It ended up being a premises liability case. And so it was not so much what did the box do, it's why did you destroy the box? And so we go through discovery, and it's a relatively small family company that's got the same name as a huge company. It's called Excel Electric, but not Excel Energy. Anyway, we're able to create what looks like a lot of smoke, different stories, different people, and we need a spoliation sanction because we cannot prove the case because we don't have the box. And so we write this motion, and I also like to lecture on writing. It's my second favorite thing. And we win the motion. We called it a $3 million motion because that's what the policy was. And we got the judge to issue, first time in Colorado history, an irrebuttable presumption of causation and liability. Meaning the jury had to find by 1% at least that the defendants were liable and were responsible for 1% of his damages. And so we're like, okay, that's great. But now they still have the chance to say our guy was fiddling with it and doing something wrong. They brought in his employer as a non-party, so they didn't train Brian on how to properly go and navigate an electrical box when your equipment's not working. So they had lots of defenses. We get into trial. This is the one fun story I got to relay. We get into trial, and we never really heard a good excuse as to why they lied about all the different times.
What was your demand before you got to trial?
So as you know, maybe not in Michigan, but in Colorado, you got to give them that policy limits demand so that you can try and open the policy up.
Right.
We said, give us the $3 million, and we prayed they wouldn't give it to us. I think our guys' past meds were 100, maybe 300,000. We had a life care plan for about 3 million. So we didn't have like huge numbers before, but something, So we demanded $3 million. They came back with $700,000. And we said, hallelujah. Now we can go to trial and really roll the dice. And they had all this, and they also, as a side note, they had all this, what do they call it in California? Sabrosa video? What do you guys call it in Michigan?
Surveillance, usually. Surveillance.
Yeah, we're simpletons in Colorado. We just surveillance. We don't have any fancy names for it. I know what that meant here. What do you do with Sabrosa? The who?
Yeah.
So anyway, and so there's videos of him like playing, swinging the baseball bat with his kids, teaching them how to play football. So they felt really good about their case. So we go to trial, and it's a company owned by these 2 brothers, the Heil brothers. And in opening, the defense lawyer gets up and she says, and look, there was a lot of confusion by the defendants, by the Heils, as to when they destroyed the box. And that's because when this all happened, their father was in hospice. The patriarch of the family, who had built this company, he was passing away. And so it was just end of life things. It was very difficult. And so just dates, it was a hard time for them to think clearly. Okay, well, we hadn't heard that before. That's interesting. Maybe we should double check and see if that's the truth. So turns out it wasn't. That was a lie.
Oh, no.
Yes.
How'd you find that out?
So Sarah, who's one of my partners now, the Boulder Daily Camera news articles, obituaries as they were looking for, and the coroner reports. Those were all accessible online. So it was a year prior. And so all that, the time of mourning, the time of it's such
Oh
grief.
my gosh.
It was long gone. Not that they're not allowed to grieve for the father. Of course they are. But this was not the reason that they were telling different stories, obviously. So John, when you try your cases, I'm guessing you do what I do and most lawyers do. You call their witnesses in your case in chief.
Yeah, adverse witnesses. Yeah, absolutely.
Let me ask you this. In Colorado, I can't stand this. In Colorado, once we do that, the other side's allowed to lead them because now it's their cross-examination of their own witnesses. How does that work in Michigan?
Yeah, that's a good question. It depends on the judge. Some judges will say no. Other judges will allow them to lead. Generally, they're not allowed, but that's a lot of the judges have different rules of evidence. It seems like,
I know that's right. Depends on the courtroom. All right, so we've got the brothers, and we've got this is the first week of trial. It's going well. Side note, back to the Sub Rosa, the surveillance videos. So the defense lawyers aren't showing the videos. They're just like they're just reenacting it themselves. They're like, did you know that Brian was there and he was throwing the ball and he was getting on his knees and doing these crazy things and it was a complete like hyperbolic reenactments. I was like, you know what? We're just going to show the videos ourselves. We're going to like show that these defense lawyers are lying and exaggerating, and we're going to introduce the videos, we had one of the doctors do it who we had shown it to. And we're like, do these videos mean Brian doesn't have CRPS, doesn't have debilitating neuropathic pain? And the doctor's like, no. She's like, I'm glad he's trying to do things with his children. That's what you're supposed to do. We don't want him getting depressed and sitting in his bed. Sure, this is painful. And if you're going to ask me if this is how a 33-year-old man is supposed to run with his children, I'd say no. It's pretty sad how he's running. So we flipped that defense on their head. We embraced it, and we just lead with your worst stuff and frame it the way you want to.
Yeah.
So trial's going pretty well, and then we get one of the two brothers on the stand, and we say, all right, and the way we're doing, I call him first. Then the other side gets to do their cross, and then we get our redirect. And then there's no other questions, no recross, which is great. So this is our plan. We're gonna wait for redirect because we don't want them to get a chance to go up and talk about it again. But we're gonna expose the lie about the father's death. And so we weren't gonna bring it up. And when it was on direct examination or my adverse direct, we're talking about the destruction of the box. He's like, well, there's a reason. There's a reason that we don't get the dates right. I was like, Mr. Heil, I know there probably are. I bet your counsel's going to ask about it. I'm not going to ask those questions right now. I'm just laying the trap because I wanted to end with the kaboom. So I sit down. The other lawyer gets up, and of course they lay it on thick. The father was passing away. We're all in the hospice room. Da, 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 da. Great. I get back up. All right, Mr. Heil. Ask him a few questions. I go, listen, I want to know, do I have your permission to ask you some challenging questions about your father? Of course. I go, I have a job to do. I have a client I have to represent. I have a dad. I can't imagine what it's like to lose him. So I'm very sorry for your loss. Thank you, sir. But I do have to ask you a few questions if that's okay. Yes, please do. Now, Mr. Heil, you testified that he passed away in 2018 at the same time. All this. Yes, I did. Yeah. I said, Your Honor, may I approach? You may. Now, I don't know if I did this properly by the rules of evidence, but my whole team is on pins and needles, right? They know this is going to happen. The defense lawyer has no idea what's going to happen. And so I go, if I may approach the witness, Your Honor, you may, counsel. And I say, the problem I have, Mr. I'm with two pieces of paper. This is very dramatic, slow, do the slow walk up there. I pick up the papers off the desk, look at them, take a little time. Okay, I look at Mr. High, look back at the papers, and I nod to myself. I walk up to the witness stand, and I say, the problem I have with that, Mr. Heil, is that I have the coroner's report here and the Boulder Daily Camera report here, and they both say that your father passed away a year prior to that, in 2017. And I put them gently on the table at the witness stand, and I slide them across to Mr. Heil. I walk back to the table. He looks down at the papers. He looks up at me. He looks down at the papers. He looks over his defense counsel. He looks back at me. He says, "You're absolutely right." I said, "No further questions, Your Honor." He goes, "But no, what I want to say." And the judge goes, "There's no questions pending, Mr. Heil. Back to your counsel table." Oh, dude, it was like, and as I'm going up there, I mean, the defense lawyer, my team tells me later, she's looking at me, she's looking at with the pieces of paper, she's thinking to herself, like, what is going on here? Dude, after that, the trial was over. The defense lawyer ended up quitting the firm after that. She told me at one of the breaks, she goes, "Listen, I always wanted to have a Matlock moment in trial. I never had one." Yeah. So she goes, "That was it."
That's amazing, dude. And here's what you did that was amazing with that is because I bet you were excited, right? Like you were so excited to use this. Also a little nervous because I've been there. Like it has to go off just right, but you saved it. You could have went at him hard with it on his cross. You heard your attorney say this during opening, didn't you, Mr. Heil? And that's not true. And then blasted him. But by saving it in the way that you did, it just has such a good effect. I mean, the timing of it's right. I've talked about this on the show because I've heard lawyers tell me, I don't know if you have, Kurt, but they say, I've been at trial like Ickle stuff, and they're like, those Matlock moments never happen. Those are just on TV. And I'm like, the hell they are. Like, I mean, haven't you heard people say that before?
Oh, yeah.
Like, they just don't happen.
Yeah, of course,
I mean,
of course.
I try to find a Matlock or at least a mini Matlock moment in every trial, but I had the same thing. I'm not going to tell my whole story again because a lot of listeners have already heard it, but I had a case against an ambulance company where they had the crash on video. I had mock tried the case. We had lost the case in a mock trial. I retooled the case. I reframed it. But one of the things that kept bothering me is an ambulance was going through an intersection, and when the ambulance went through the intersection, it had its lights and sirens on, so it had the technical right of way, but it's still supposed to stop or slow down and clear the intersection. It didn't do that. Now, the ambulance driver looked to the left, and he cleared the left oncoming traffic. He did not look to the right, and he just blew through the red light without clearing to the right. My client was coming from the right. She was an old lady with her windows up, listening to gospel music. It was like it couldn't have been like worse timing. The ambulance T-boned her on the driver's side. She's all fucked up. So I'm watching the video and I'm really bothered by this ambulance driver's two things. He doesn't look to the right, and his testimony was, I didn't need to look to the right. I could see it through the periphery of my vision. Which was a lie, because I went and I did the course, and there's no way he could have seen to the right.
Right.
But to make matters worse, it just bothered me that this guy, he had on these like Oakley wraparound glasses that, like, you know, you would see people wear during volleyball matches because they don't go off your face. Do you know what I'm talking about? They're they're real close to your face. And they just kept bothering me, and I kept looking at those glasses. Finally, on a whim, we went to the Sunglass Hut at the mall. I took a picture of the guy from the video. I took the glasses, and I bought a pair of the glasses. I took out the insert, and I started reading. It's this big, long insert on these glasses. And I start reading the insert, and at the top, among these other warnings, it said in big, bold letters, not for use while driving.
Ooh.
And it affects your periphery. So I had to use this. You know, I'm so excited to use this, but I can, as you're telling your story, I'm thinking of this. I'm so excited. It's pins and needles. It's when do I use it? I could have brought it up in opening. Then they're going to have an opportunity to make up some bullshit on it. I could have brought it up on my, initial direct, but I timed it right. So when I sat down, I did it right before I sat down. And, very dramatic, right? I take out these Oakley glasses. Defense counsel starts going nuts. I take out this big, long insert. It kind of flops down in front of the jury. And I had gotten the guy, and then I approach him, and I said to him, did you ever bother to, I said, these were your glasses, right? He's like, yeah, they look like them. I said, well, it says right here, gunmetal, Oakley 3.0. That's your model, right? He's like, yeah. And I said, you still drive with those today? He goes, yeah, all the time.
Okay.
I go, you drive to the courthouse today with them? He's like, yeah. Did you ever bother to read the insert? And he gets all nervous. And then I ended with, I had highlighted, I said, why don't you read to the jury what the Oakley Corporation says you cannot and should not do? What does it say? He says, do not wear while driving. And I said, what were you doing? He said driving. And it was like the drop, right? There's not a better feeling, Kurt. And the jury was on the edge of their seats. And it's like, oh, I don't know. Did the jury do a reaction when you did yours? Like, or was it just like...
It was like, it was just complete silence, like shock, like jaws on the floor. I wasn't looking at the jury. I didn't want to it's always that balance. You don't want to seem cocky.
Yeah.
And I'm like, I got him, But so my team
Right.
was watching, and they said they were just like aghast, aghast. And it doesn't always work, But you got to try it. I mean, you got to take risks in trial. You got to get creative. And what I love about your story, John, is you bring in the fact that he's still doing it today, right? So he's still endangering people on the road that maybe the jurors that were driving here today, driving with bad peripheries, and then you just the drama you created in that moment. And I'm talking about drama at the Michigan Trial Lawyer Summit. That sounds like a perfect way to do it. You build the anticipation. You have a prop. You bring it out. You let it fall. You read it. You wait. I mean, that's like. You can create those Matlock moments if you plan them the right way.
Right. And we had planned, and we had talked about when are we going to do it? How are we going to do it? And everybody's nervous. So that'll never work. What if he says this and says that? And I'm like, come on, let's just try it. And here's how we're going to do it. But I had a backup plan. If he said, those aren't my glasses, I had a picture that I was going to say, well, here we go. Why don't you put these on? And then I was going to put the picture next to him, and say, let the jury. But you got to have plans. But I really liked what you did with that, Kurt. And so you got the largest premises verdict in the history of Colorado. Did they pay it? How did it work?
Yeah. So it's interesting. So after that was like a Thursday, and the trial was going to go to the next Wednesday. So on Friday they offered the $3 million, and
too late.
And I was like, too late. But my guy had to have the cojones, to say no. I mean, that's a lot of money to walk away from. But I'm like, Brian, you're a baseball guy. We're in the seventh inning and we're up like 8-0. Like, we got to see this thing through to the end. Just the money will never go away. If next week goes terrible, but just trust me on this. It's going to go well. He did. We rejected the offer. We got the $16 million. I had a juror call me afterwards, like 2 weeks later. She's like, "Did we give him enough? Is that going to be enough for him?" I was like, "Yeah." And these jurors were great. I do this thing. I memorize their names in jury selection. Everyone should do that. I was just on Dan Kramer and Harry Plotkin's podcast about jury selection, and we're talking about that. So everyone should do that. But the same juror had come up to me at lunch in the middle of jury selection. She's like, "I really appreciate that you memorized our names. Like, it shows you care." And at that point, I thought it was just kind of a parlor trick, but it plays so well. So anyway, the jury was great. They did the heroic thing as we asked them to. And then what happens is, because the policy was only $3 million, the insurance company had to bond the entire $16 million. Ended up being like 15.1 when you do some damage cap stuff and whatnot. They had to bond that with the Court of Appeals and put the whole 15 million, 16 million in. And we go to the appeals, and if you win the appeal, you get the money. And so it was a 2-year appellate process. We got a 63-page, 3-0 published opinion in our favor. And now that case, Warrenburg versus Excel, is the seminal spoliation case in Colorado that the Attorney General cites in all their preservation letters. It's like the case, and I got a chance to argue the Court of Appeals.
That's great.
It was wonderful.
That's great. That's great. Tell us about your electrocution case, because I called you. I have this big electrocution case here in Michigan where this dude got very badly electrocuted, and I've had to learn a lot about electrocution. You've done other electrocution cases, haven't you?
Yeah, so that was my first one. And again, there was no visible burns on this kid. He said there was, but no one saw them. This young adult. And but that's where the first time you do a certain kind of case, you kind of crack the code. You figure it out. Now you know how to do the rest of them. You got your experts lined up. You know what kind of things they need for medical care and who can really tell the story well for you at trial. So then I think I was doing like a CLE on this case, and someone in the audience, he's like, "I got an electrocution case." I was like, "Great, let's do it." And so we got our same team together, and this was it was another CRPS case. When you start doing these electrocution cases, you end up usually with one of two kinds of injuries, aside from terrible burns, is you get what they call neuropathic pain. That's the kind of pain that is associated with CRPS. You don't need a CRPS diagnosis to have neuropathic pain. There's a whole podcast on that. Do you want the diagnosis? And then you also see a lot of electrical injuries to the brain, as I know that you're dealing with in your case.
Yeah.
So this guy had both. And the thing about either of those, absent the burn marks, we don't have them, is that people look kind of normal. They seem kind of normal. And then you ask for these, 8 figures, and people, it's a big hump to get over because they're not missing a leg, more of an invisible injury. So in this case, this is a crazy case. All cases are crazy. it's like when you do this work long enough, as you know, John, like you see tragedy at every corner because like people are just screwing up all the time. All right, so mobile home
makes it hard to be a dad, dude. Like my kids are like, why can't I do this or why can't I do that? I'm like, let me tell you about this case. You know, it's
so true, and then they become like, and you want your boys and your kids to take risks. I mean, that's part of like becoming a young adult. But I mean, we see. So here's what happened here. This was a mobile home park, construction site. You got a mobile home on one side, and you have this like electrical pedestal with the breakers in it, about 30 feet away. Same kind of thing as before. But in a mobile home, these become, you don't have breaker boxes in your mobile home, you have them like outside. And so it's a box. It's a little bigger than the box in the last case. It's about, 3 feet tall on a pedestal, on a pillar. And my guy is hooking up, he's an electrician, he's hooking up the power lines from that box over to the mobile home. And so there's like a big trench that's between the two where the power lines are going to go between the box and the mobile home. And he goes there, and prior to him getting there, Xcel Energy, now this is the big boy Xcel here in Colorado and other places, they had set up all this electricity, all this energy as they call it. And he goes there, and this box is supposed to have the wires running from the generator, which is where the power comes from. It's supposed to be generator wires into this box, and then he was going to put wires from the box over to the mobile home. And what he doesn't know is inside the box, the wires from the generator, there's these 3 big wires about, I don't know, if you're watching, you can see on my hands, maybe about 3 inches thick. They're supposed to be like connected inside the box. They call it being terminated. And they weren't. Some lazy workers from the company Xcel hired, they forgot to connect the wires. They just left them there.
And were they live wires? Oh my God. Oh my gosh.
Live wires. And they're just laying in the box, like inside, and the box is closed, so you can't see it. It's locked. You can't open it. Only Xcel can do that. And so my guy doesn't know this. He's just doing his job. And luckily these boxes, they have coating on them, like paint, that should prevent, even if it's live wires inside, from electricity being conducted. So we should be okay still. Unless, and this is great, wild cases, unless he just happens, there's a little itty bitty like 1-inch clip where the lock is on this box.
No.
That would be the only part that's electrified or energized. You would have to.
And how much energy? Is this like a lot of energy?
No, it's 120 volts, which became a huge issue in the case because they're like, nobody gets hurt from 120 volts. That happens all the time when you're unplugging your toaster. 120 volts is no different than drinking a strong cup of coffee in the morning. I mean, all these like crazy experts. Oh yeah. So that became a battle within the battle of we had to get the guy that says 120 volts can really harm you, and they had their like double Stanford PhD glasses bow tie guy that would say nobody could ever be hurt by this. So battle of the experts. We'll get to that in a second. And so my guy would have been safe, but he just happened to as he's walking over that ditch where the cords are, where he's putting the power lines, his elbow hits that teeny tiny little electrified piece of metal, which is the lock on the box. But that's not enough. He then has to be grounded and touch something else. And while he's walking past this and his elbow brushes it, he grabs a gas meter on his right-hand side. And that gas meter is what grounds him. And then as touches the elbow with the left elbow and grabs the gas meter with his right hand, that's when that's when he gets electrocuted. And he doesn't know how long he's on there for. He ends up getting off himself. I mean, this is like your case. It's not like these crazy huge electrocutions, right? These are like, okay, he had a little shock, big deal. But it was a big deal, and he got CRPS, but he kept working. He was okay to finish working that day, and for the years afterwards, he never gave up his job. So that was a big deal. They're questioning how can he be hurt? How can he ask for $60 million if you can work every day? So that was it was a challenge, man. We had a guy on the jury, John, that was a construction worker that had been shocked by 120 volts a dozen times and never been hurt.
Why did you leave that guy on?
Because everyone else was worse. We had an insurance adjuster on the jury.
Stop.
Yes, we had a white shoe law firm lawyer, business lawyer, as the foreman of the jury.
You got to be kidding me.
Dude, I picked the jury like, we're going to lose this case. This is unwinnable. Because you get 30 minutes of voir dire in Colorado, and it was just the worst panel ever. So for trial, they bring in these fancy trial. They do this all the time in my case. So they brought in these fancy trial lawyers from California, who are like the big guns, come beat me up. I think we asked for, I don't know, I think we were something like 5 or 8 million. They ended up offering $1 million before trial. They came in and were bad, and it became, I don't know, they do, John, when you get these big trials, they find trial counsel.
Yeah. So so there used to be this guy in Michigan called Jon Eads. He was kind of the cream of the crop defense lawyer who, if you had Chubb or any of these big companies, when I get brought in, which a lot of times is, a month before trial, 2 months before trial, 6 months, whatever, I would get brought in, and then the defense, or it's my own case, would then bring in this guy named Jon Eads, okay,
Yep.
as like the crusher. So I ended up hiring Jon Eads. He works for me now. After he was brought in about 5 cases last year. And so now they're scrambling. I have another case we can talk about after this, but I have another case where the insurance company is now actively trying to find, they don't know who to find because our defense bar in Michigan has gotten bad. But yes, the answer is yes. They try to find somebody to bring in to try to counterbalance. And I take it as a compliment. I'm like, how many lawyers have I gotten fired off these cases?
Right. And I always find, John, that I become friends with these guys because they're just hired guns. They just want to go have a fun trial. They're not like, they haven't been in the weeds for 3 years on it. And so I always buddy up with these guys. And
me too. That's why, John, I'm like, dude, you should work
really
with me.
Really nice to them. I compliment them.
Yeah, yeah.
Right. No, it always comes with like, we're going to find a case to work together. Big plaintiff's case. I love that you hired him. That's hilarious.
Yeah.
So these guys come in, we whoop them. We get, and we have this defense expert, the bow tie guy I was talking about before, and I had him on the stand for like a whole day crossing them, which is too long. It is too long. But
what is he, like a neuropsychologist or psychiatrist or something? Or
no, he was he wasn't on the injury. He was like a PhD, MD, electrical engineer, etc. So many letters at the end of his name. But he was like the guy, Dr. Kroll. And it was during a little break. So what I do for Cross is I always cut a bunch of clips from my depots. I usually 100 to 200 clips for each witness. And who knows when they're going to lie. And I got to play one of those clips and make them look like a liar on the video screen. And I played, I don't know, about half dozen, 10 clips with this guy. And at one of the breaks, he's in trial. I'm like, he's like, Mr. Zaner, all right. And we would go toe to toe in 2 or 3 depots, did not like each other. But he comes up to me and he's like, he's sitting in the witness stand at break. He goes, Mr. Zaner. I walk up there. He's like, let me just tell you. He's like, I've never been cross-examined like this before in my life. He goes, I will never not be more prepared than I was today. He's like, this was the tip of the hat to you, Mr. Zaner. And I was like, yes.
Dude, that's like the best compliment you can get. That's like, remember in the O.J. Simpson case when like the DNA guy came and shook the O.J. Simpson's defense team because they kicked his ass so bad. I mean, it's
like, game recognizes game. So we crushed him. We had the last you talk about crazy stories. What's wild cases. So this is the last part of this case, which is worth telling. This part of the story. So this client was very similar to my former client, the one on the $16 million verdict. He had CRPS, some of the same symptoms. And so what was really interesting is that my client's treating doctor in the first case said, all these things are indicative of CRPS, X, Y, Z. And that's clearly what would be a CRPS diagnosis. Okay, these factors. She gets hired by the defense in this case against me, the same doctor. And she's like,
what?
XYZ doesn't cause CRPS. I was like, oh, okay, here we go. And so I get to cross-examine her. And of course I want to bring up Brian's case, because, but I knew they'd like fight about, like, she'd like HIPAA, I can't talk about him. So I had my client who loves me sign a HIPAA release for trial, my former client who had her as a doctor. And so I get up to cross-examination. I was like, I'd like to talk to you about all these factors that you said don't cause CRPS or aren't indicative of it. And I want to bring up Mr. Brian Warrenberg, who was a patient of yours. Well, that's right, he was, but, counsel, I can't talk about him because I have HIPAA issues, privacy. I said, Dr. Mason, I thought you were going to say that. So what I have here is Exhibit A is a HIPAA release from my client, your patient, Brian Warrenberg. If I may approach, boom. And then Now, his whole case is on display, and we just cross her with all the things she said that were the complete opposite of all the things she's saying in this case, and it was just beautiful.
That's amazing. So that you got that. What was your verdict on that? I think it was
So that one turned about $10.5 million when all was said and done, and they
yeah,
did.
it sounds like a tough case too. I mean, tough damages case. It sounds like that. Sounds like the rub.
He had 100,000 in medical bills. Not a mark on his body. He never stopped working. It was 120 volts, and we just what we like to do is bring in witnesses. We call them groaners in Colorado. Everybody else does that, and just to help paint the picture of all the things he's lost.
So how did you do it? How did you do it, Kurt? I mean, on with those damages being somewhat difficult, very difficult actually. I mean, what was your key to success if you could sum it up on that?
I think it's getting to know the client's story so you can tell it in a really compelling way. We had great testimony from his wife, great testimony from his friends, from people in his life. I mean, that's the least legal aspect of the case, but maybe the most important when it comes to damages is getting that human story out there. And so, with medical bills, can't show you. And by the way, he had terrible prior meds that he had, like sleep apnea, which caused all his brain fog. And, he had prior pain and this and that. So, we had so much to deal with. But, just telling the human side of things, I think is a big component of starting with getting big damages. I think the lawyer being credible throughout and not overplaying your hand is a big deal for when you come to that ask. And I think it's important to kind of get them used to money early on. I think this is not rocket science. We talk about it in jury selection, opening, and all that. So when they hear these big numbers at the end, they're ready for it. But it's different when you have someone with cancer or amputations or crazy burns. It's those invisible injuries where you really got to dig into those human stories.
And let me ask you this: what about with this jury? Did you talk to them? Were they against you at first? I mean, this is I couldn't come up with a more bad jury on a piece of paper. If I was an insurance company and I wanted to stick it to you, this would be who I'd put on. I mean, those people.
The foreman of the jury was a white shoe corporate lawyer, and he talked to us. He's like, "Dude, you guys squeezed every dollar of damages out of this jury that you could possibly get." And we asked for a lot more. We had a punitive damage claim, and they didn't find him. It was a very creative punitive damage claim. I mean, this was clearly an accident. Some guy left the wires in there, but we were able to. It wasn't intentional. It wasn't reckless, but we were able to create a punitive claim. The judge allowed us to add it, and so they didn't give us punitives, which I thought was probably the right decision, especially with this jury. And he's like, "Look, you squeezed every dollar out of this jury. You guys did a great job. The one piece of advice I would give you," he said, "is maybe make the point only 3 times that you're making, not 7 times, so it gets a little repetitive."
Dude, it's funny that you say that because do you know who Jeffrey Feiger is?
Yes.
I mean, I worked with Jeffrey in the Midwest. He was considered the greatest lawyer in Michigan for sure, and in the nation, right? I mean, he did the Kevorkian stuff. So I trained under Jeffrey. I became a great trial lawyer because I trained with Jeffrey, and Jeffrey would take me with him to these trials across the country and would fly around in his jet and would go to these different trials. And I learned so much from him. And one of the things that Jeffrey would do is he would make the same point 10 different times by slightly altering the evidence or the question. And juries would always say the same things to Jeffrey. They would say, we got it. It was obvious to us.
Right.
After all my cases, so I just tried, last year I think I tried 7 cases. Wow. And on almost every case, the jurors said, I always say, tell me, is there something I can do better? Is there something you don't like? I want to get better. So just give me your criticism, not necessarily just the good things. Okay. And they say to me almost every time, invariably, "Mr. Marko, we got it. You didn't need to tell us the same thing 10 times. It was obvious." But, and I had some people on my team tell me that. And I said, yeah, it's easy when everything's all said and done and all over to look back and say, it was obvious. We got it. But I'm not changing anything. If that's the criticism, that I say the same thing 10 times or that I hit the point 10 times, it's driving it home. And maybe by the end, they get it. But my philosophy is you got to do that. You got to hammer it in. You got to hit those themes. What are your thoughts on that?
John, I couldn't agree more because I just had this go the other way on me. So as you know, I just had my first trial loss It was a 6-week mass tort, toxic tort, Aaron Brockovich type case. We had some Aaron Brockovich. It was wild. It was the first bellwether. We got another one coming up, so we're going to retool and get back out there. And this trial, because it was 6 weeks long, I was more cognizant and conscious of not making the same point 1,000 times. And we lost the case. And I can tell you, we spoke to one of the jurors, and it seems like he didn't understand all the points we're making. And I think that's because we didn't hammer them home. And I totally agree. If you have to choose one of two options, they really understand the case, but you think you're overdoing it, or they miss all your good points, I would go with door number one on that one. So I beta tested this in the biggest trial of my life and failed. And so next time we go, we're going to be hammering the same 6 points over and over and over, because they don't know when they get it. They just know how they rule. And like, good, I'm glad you got it. That was the point.
Yeah, exactly. I look back at some of my, some of the lawyers that I work with, the younger lawyers, and I'm like, this is easy. Like what, this is easy. This is easy. But then I actually take time and think back when I first started on it. It wasn't easy. And it took some time to get that wiring in my brain of now what is just automatic and instinctual. And I don't have to have that brain barrier of thinking, taking action through my brain and processing, because it's automatic. It just happens. But it takes time to get there. And then it feels, looking back, oh, it's easy, So I totally agree with that. And when they were like, you should change your style, I said, I'm not going to change that because I'd rather do that, like you said, than be cautious. Can you tell us a little bit about this trial that you had that was this toxic tort trial? I know we talked about it.
Yeah, sure. I mean, I've always wanted to take that step from, doing single event cases to being the Mark Lanier, the mass tort, come in for the crazy trial. And so I had all these string of successes. The one we didn't talk about today, maybe for another podcast, was we had a $30 million fracking explosion case that did have amputation, all sorts of crazy stuff. And that was in federal court about a year and a half ago. And then that was my last kind of warm up before going, for the 9-figure case and clients that they're dying from cancer. So it's this medical sterilizer. There's been 6 or 7 of these trials around the country. There's been 2 wins, 5 losses. But our company is called Terumo, and they sterilize, it's a Japanese company. They sterilize medical equipment with what's called ethylene oxide because ethylene oxide is highly carcinogenic, mutagenic, and genotoxic, which means that when you blast medical instruments with this carcinogen, it kills everything on it. That's the whole point. It's to sterilize.
Like scalpels and stuff, are we talking about?
I mean, it can be, for this particular case, it was more they're doing like tubes, like blood tubes they put in you for like stem cells and things like that. But yes, this is the sterilization method du jour for a lot of these things. I thought it was
And is the plant in Colorado, or where's the plant?
It's in the middle of a city in Lakewood, which is like the key to the road, which is the gateway to the Rockies. So there's schools all around it. And so what happens is they used millions of pounds of this. I think 7 million pounds over the decades, 5 decades, 50 years. And it's odorless, it's colorless, and we allege that they did a really poor job of containing it after, killed all the stuff on the instruments. And it doesn't kill it all instantly. It's like it messes with the microorganisms' genes, and so they end up dying eventually that's why it's genotoxic, meaning the genes get affected. And so the residents around here breathe it in. It's odorless, color. They had no idea for decades. And the studies have shown that it is associated with causing 2 kinds of cancers: blood cancers, leukemias, and breast cancers. And so it was a very challenging case. They have a great causation defense that says, they weren't exposed to enough of it to cause cancer. It's much, much lower levels. And we said,
so no. Was this people in the factory, or was this being released into the atmosphere, or what?
Being released into the community. So it's all people that just live there, work around there, play around there. In Colorado, you can't bring a claim against them for a worker, because it's workers' comp immunity.
Right.
So and it's interesting. We talked about it. So it was massively complex. 50 years of behavior. We got to show they did something wrong every year, all along the way, potentially.
These toxic tort cases are incredibly difficult, complicated, and they cost a lot of money. And I'm guessing this case did as well.
Oh yeah, yeah. They just submitted their cost bill yesterday. The defense, $5.5 million is the cost bill they think that our patients, our clients dying of cancer should pay. I mean, just like truly evil stuff. But yeah, this is multiple seven figures in costs. And just I think I did probably like 60-70% of the witnesses. I did too much. We had co-counsel who's amazing out of Chicago called Edelson. They had two plaintiffs. We had two plaintiffs, and it was just a slog, man. It was really tough. We had a great judge, and a lot of evidence came in, and it was, they came back after 2.5 days with a defense verdict, which was, a gut punch to say the least. But, and I went into like recovery for like a month, didn't really do anything. It was really, really hard. And
yeah, how are you feeling?
We took risks, John, and they didn't always work. You get the great obituary, Matlock moment, and then sometimes you try and it fails. The witness doesn't do what you want them to do.
Can you give us an example of like some risks that didn't work?
Yeah. So we brought in this lady, Miss Duffy, who used to work there, and she worked there at the time. She was their accountant, and I spoke to her on the phone ahead of time. She had a lot of choice things to say about her employer, about not about employer, but about like whether she felt safe there, with all the toxins going into the atmosphere and the carcinogens. And then she got in the stand, and she still worked there at the time, and her bosses were there, and the legal counsel for the company was there, and she didn't give us what we thought she was going to give us, and like.
Do you think she was like a plant, like they told her to go there?
No, I think she just got nervous. I think she just couldn't do it, and then she's now, I think, like watched the trial. It was on CVN, and she quit. And she's like, I didn't know half these things. And she's like, I'm sorry, I didn't. I thought this would be the Matlock smoking gun witness that would say, I work there, I feel unsafe, et cetera, et cetera. And it didn't come out that way, and it hurt us, and that's okay. It was still worth the risk. You have to take risks, and so we learned a lot. There's this former Navy SEAL, Jocko Willink. Jocko Willink? He writes kids books now. There's a great one called Warrior Kid. If you got a boy or a girl, you got to read it with your kids. It's amazing. But he has this thing. Does a podcast, and he's got this little 2-minute clip that's called. And he says, "Good." He's like, bad things happen to you. Good. That means you got a chance to learn from them. If you can say the word good, that means you still got some breath and some fight left in you. So that was, I recommend your listeners.
It's tough, man. I mean, I have been on a terror run. I mean, it's been like over 10 years since I had a loss.
Yeah.
But, and some people will say, well, you haven't been trying enough cases. I've been trying. I mean, I've been trying to do it, but I have lost. The first 3 cases I ever tried, I lost. So this is the first. I want to be a trial lawyer. And I lost the first 3 cases. 2 of them I probably should have lost. Looking back, I think the jury did the right thing. The third one I should have won, and I lost. And so it's tough, but I learned more through those losses, I think, than I did through the big wins. So do you have any advice to other lawyers out there who are going in a battle and are scared to lose or do lose?
Yeah, let me give some advice, because I was like you. I was on that 12-year tear. This is my first civil trial loss. You lose criminal trials, you have to.
Yeah.
Well, I won a lot of them. But I was tearing them up, ching, bing, bing, hitting jackpot justice. Just kidding, not jackpot justice, but ringing the bell on these insurance companies. And so I'm unbeatable, I'm thinking, right? And this was my first loss, and it was devastating. But the advice is sometimes you're going to lose cases. Sometimes you're going to get those jurors that you couldn't have avoided, and they're just not going to be good for you. Sometimes defense is going to have tactics you couldn't foresee, or that come in, and you do your best. And it doesn't mean that you wasn't worth the fight. It doesn't mean that means you're a bad trial lawyer. It just means that you're going to lose a battle every now and then, and that's okay. And I'll tell you what, when I win my cases, I don't do much reflection. I had a near loss once in Florida, and it felt like a loss. And so the whole plane ride home, I rewrote my closing. This loss, I've been rethinking all sorts of stuff. Now, like you said earlier, I'm not going to change everything I do because of one bad jury and one loss. I'm going to take some lessons from it. But it's part of being a trial lawyer. I mean, the people I look up to have all lost cases. One of my heroes, Cicero, the great Roman orator, the great Roman trial lawyer, he would lose cases, and he would get so nervous before the next case, where they had these big public trials in the Roman Forum, which is like the city square. He would throw up. He was so nervous after the wins, after the losses. So it's like, you're doing the right stuff. Don't let it get you down. Don't let it change you as a trial lawyer. Just become a better trial lawyer by reflecting and figuring out what it is you could do a little better next time. And now I think I would be strategizing a little more. I feel like maybe I was getting by a little bit shooting from the cuff. I'm like, I got this. Like you were saying, things are automatic. I got it. I'll figure it out. I'm going to plan a little more next time and really narrow this down. And it's okay. Like, don't get back in the saddle. Put on that armor again. Go fight and slay another dragon. Because you know what? A lot of lawyers don't want to do it. Most don't. Most take shitty settlements.
Right.
I talked to a lawyer the other day. Shitty settlement. He was proud of it. Don't do this. Go fight the battles.
Yeah, and it's hard. 6 weeks. That's a long time. I had my longest trial was 6 weeks. I'll tell you what. Even if you win, it is exhausting and it takes a lot out of you. And I got to give you credit for going out there and fighting and continuing the fight. I always tell my lawyers, look, I said, if they said, well, I'm worried about this case. I said, listen, if you go out there and you do your best and you fight for your client, I promise you will never hear any negative thing from me about the decision to go and try the case, and it's like Teddy Roosevelt said, you got to get in the arena, so Kurt, I thank you, man, for being here. You're a great human being. You're a great lawyer. You're a great friend.
Thanks, John. Me too. Can I leave you guys with that? This was great. It's a lot of fun, even on Saturday morning. And you guys didn't see my kids, but they were here.
And I apologize. We try to do it during the week. I was trying to find, it's almost impossible with schedules to get everybody. We got my production team here, and it's
all good. It's an honor to be here. Let me leave you with my favorite Teddy Roosevelt quote, because he was my hero growing up. There's a great trilogy, the Edmund Morris trilogy, The Rise of Theodore Roosevelt, and then it's just incredible. Everyone should read this book. But my favorite Teddy Roosevelt quote is, "Far better it is to dare mighty things, to seek glorious triumphs, even though checkered by failure, than to take rank with those poor spirits who neither enjoy much nor suffer much, because they live in the gray twilight that knows neither victory nor defeat."
That's great, man. We're going to leave it at that, man. Kurt, thanks a lot, and we'll see you soon in Detroit, baby.
Awesome, dude. Thank you. Looking forward to it.
All right, thank you. All right, everybody. It's been another great episode of Cases Gone Wild with our special guest, Kurt Zaner, out of Colorado. He's an amazing lawyer, amazing person. If you are someone needs help, you need to call Kurt. If you're in Colorado or anywhere that needs help, call Kurt. Call us. We'll get you connected to him. You can go to markolaw.com, 833-MARKO-LAW. We'll see you in another 2 weeks on another episode of Cases Gone Wild.